So in today's video, we can see what is third-party insurance, role of third-party insurance in MACT, and the Motor Accident Claims Tribunal. So yesterday we have discussed about no fault liability with respect to motor accidents, MACT, MACT Act, and today we can see third party insurance, role of third party insurance, and the last motor accidents claims tribunal. So these are the topics that we are discussing today. So first of all, we can see third party insurance. Third party insurance is a type of motor insurance that covers legal liability towards a third person, someone other than the owner or driver of the vehicle, who suffers injury, death, or property damage due to an accident caused by the insured vehicle. It is mandatory under Section 146 of the Motor Vehicles Act 1988 for all motor vehicles in India. Section 146 of the Motor Vehicles Act deals with compulsory insurance for motor vehicles. Section 147 of the MV Act mainly deals with requirements of policies and limits of liability. And Section 149 of the Act mainly deals with duty of the insurers to satisfy judgments and awards against persons insured in respect of third-party risk. So simply, what is meant by third-party insurance? So third-party insurance mainly means that if if a person when he drove a vehicle and when he hit a person or another person's property, as a result of the accident, what happens, some damage or injury has been caused, then what happens, this third party insurance actually helps you to compensate to the victim. So you don't have to pay the money, you do not have to compensate the money. So when we take third party insurance, this third party insurance helps you to compensate the victim. So this is the main idea of third party insurance. So once again, when I say about third party insurance, so in uh, So once again, when I say about third-party insurance, for our simple understanding, what is mean by third-party insurance? So when a person's when a person hit a vehicle to another person or to another person's property, as a result, what happened? As a result, a damage or injury has been caused. So it is not necessary for you to compensate. So when you take third party insurance, this third party insurance actually compensate to the victims. So this is the main idea of third party insurance. And according to section 146 of the Motor Vehicles Act 1988, it is mandatory for all the vehicles to have third party insurance. Okay, so and we can see the sections that are dealing with third party insurance. So section 146 of the MV Act mainly deals with compulsory insurance for motor vehicles. So always remember that section, that is section 146 of the Motor Vehicles Act mainly deals with compulsory insurance for motor vehicles. And coming on to section 147, section 147 actually deals with the requirements of policies and limits of liability. That means requirements of this insurance policies and the limits of liability. So these requirements are mainly discussing in section 147 of the MV Act. And coming on to 149, 149 mainly says about the duty of the insurers to satisfy judgments and awards against persons insured in respect of the third party risk. So these are the three sections that are mainly dealing with third party insurance. So always remember these sections. Okay, now so this is the concept of what I said now is the concept of the third party insurance. Now we can see third party insurance with respect to role of third party insurance in MACT. Oh, okay. Okay, so we can see role of third party insurance in MS Accidents Claims Tribunal is a special court that handles claims for compensation arising from road accidents. When an accident occurs, the injured person or legal heirs of the deceased can file a claim before the MACT. The insurance company of the vehicle is made a party to the case because of the third party liability coverage. The insurer is legally bound to pay compensation to the victims as per the policy and the MACT award. So here we can see how the third party plays in the how and what is the role of third party insurance when it comes to motor accidents claims tribunal. So we all know that the main court that deals with the compensation with respect to road accident is motor accidents claims tribunal. We all know that, and it is actually deals with all the accidents that arises from uh, that means it actually covers all the things that arise from road accidents. So here what happens when an accident occurs, actually the injured person or legal heirs of the deceased can file a claim before the MACT. We all know that when any accident occurs, the injured person or any of the legal heirs, even if the injured person has died or he is unable to file um, the claim before the MACT, his legal hire can claim to MACT. Then what happens? The insurance company of the vehicle is made a party to the case. So after giving after claiming before the MACT, the insurance company is made one of the party to the claim because of the third party liability coverage. Because of what? Because of the third party liability coverage, because this insurance company has to compensate to the victim. So that's why the insurance company is also made as a party to the case. The insurer is legally bound to pay compensation to the victims as per the policy and MACT award. So as per the insurance policy, and even the motor accident claims tribunal has pronounced an award. So as per this policy and as per the award, this insurance company have to compensate to the victims, and they are legally bound to compensate to the victims. So this is the main concept of role of third party insurance in MACT. So once again we can see how the third party insurance how the role of third party insurance in MACT. So in simple term, it means that when an accident occurs, what happens when an accident occurs, the injured person or any of the legal heir, they can claim compensation to the motor accidents claims tribunal. So while claiming the compensation, what the 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 insurance company is made a party to the claim. Then, as a result of the award which is pronounced by the MACT or as per the insurance policy, this third party insurance is legally obliged or legally bound to compensate to the victim. So this is the main concept of third party insurance. I hope you all got this point. Okay. Now we can see the coverage. The coverage under third party insurance. So under what all circumstances the third party insurance is get covered. Third party insurance covers death or bodily injury to any person other than the insured or driver. We all know that mainly to the victim actually this third party insurance is compensated. So third party insurance covers death or bodily injury to any person, damage to property of a third party up to the statutory limit. Mainly remember these 3 points: death or bodily injury to any person, damage to property of a third party, legal costs incurred in defending claims. So these are the coverage. These are the these are the coverage where the third party insurance covers for mainly these 3 things. First one is death or bodily incurred in defending claims. So always remember this three insurance covers. Okay. So these are the coverages. Now we can see Motor Accidents Claims Tribunal. Okay, so we all know that what is mean by Motor Accidents Claims Tribunal. So when a road accident occurs, all the things that deals with the accidents, the insurance, the compensation, and the award and everything are mainly deals with everything is mainly deals with Motor Accidents Claims Tribunal. So, the Motor Accident Claims Tribunal is a special court established under the Motor Vehicles Act 1988 to provide speedy and effective justice to victims of motor vehicle accident or their legal heirs. So, um, we all know that Motor Accident Claims Tribunal, it is actually a special court, right? So, it is mainly established under current act is Motor Vehicles Act 1988. So this particular act is established under Motor Vehicles Act 1988 to provide speedy and effective justice to whom? To victims of motor vehicle accidents or their legal heirs. So this is the main concept of Motor Accidents Claims Tribunal. It deals exclusively with claims for compensation arising from death, bodily injury, or property damage caused by road accidents. So mainly, Motor Accidents Claims Tribunal actually compensate to what all things. Mainly, it exclusively deals with claims for compensation which arises from death, bodily injury, or property damage. So always remember these three terms, that is death, bodily injury, or property damage caused by road accidents. Sections 165 to 176 of the Motor Vehicle Act 1988 deal with MACT. It was created to replace civil courts in handling motor accident cases to make the process faster and simpler. So section 165 to 176 of the MV Act mainly deals with Motor Accidents Claims Tribunal. And we all know that this particular tribunal was created actually to replace civil courts in handling motor accident cases and also to make the process faster and for speedy remedy. So this is the main concept of Motor Accident Claims Tribunal. Now we can see the composition of Motor Accident Claims Tribunal. So this particular tribunal is established by the state government by notification. Okay, the state government establishes the tribunal by notification and it consists of one or more members. So the one, it can be one or more than one or more members. The presiding officer is usually a district judge or additional district judge. So who would be the presiding officer? It can be a district judge or additional district judge. Now if the award is not satisfied for the claimant, okay, then if the award is not satisfied for the petitioner, then what happens? He or his legal heirs can file an appeal to the High Court. Always remember, to High Court under section 173 of the Motor Vehicles Act 1988 within 19 days. So within 90 days, he or his legal heirs can file an appeal to the High Court. Okay, under section 173. So these are the concept of Motor Accidents Claims Tribunal. So once again, we can see the topics that discussed now. First, we saw third-party insurance. So what is meant by third-party insurance? Third-party insurance is a type of, so we saw that third-party insurance is a type of motor insurance that covers legal liability towards a third person. So, here the third person means someone other than the owner or driver of the vehicle, then that such person have to suffer injury, death, or property damage due to an accident caused by the insured vehicle. So this is mainly the concept of third party insurance. So if we say in simpler terms, third party insurance means if our vehicle, if we hit a person or a person's property, as a result the injury has been caused to that person, or as a result the any damage has been caused to another person's property, then what happened? Then this third party insurance would help to compensate to that person injury, to that person's injury, or if any damage occurs, that a particular insurance company helps to compensate for the damage. So this is the concept of third party insurance, and we saw according to section 146 of the Motor Vehicles Act 1988, it clearly states that it is mandatory to have third party insurance for all vehicles. Okay, so it is very necessary to have third party insurance for all vehicles, and this is mainly discussed in 146, that is section 146, compulsory insurance for motor vehicles, and section 147 mainly deals with what, the requirements of policies and limits of liability. Okay, the requirements of policies, they that is the insurance policies requirement and the liability limit. These are the things that are mainly discussed in section 147. And section 149 is what? So section 149 is the duty of the insurers to satisfy judgments and awards against persons insured in respect of third party risk. So this is the main sections that is deal with third party insurance. Then when we say about role of third party insurance in MACT, so this we saw that after any road accident has been occurred, what happened, the insured person or his legal heirs can file, in simple terms, can file a case before the Motor Accident Claims Tribunal, and they can add this insurance company as one of the party. They can made a party. They can make this insurance company as one of the party, and the insurance company is legally bound to compensate to the victims as per its policy standards and the MACT award. So this is the main concept of role of third party insurance in MACT. Then after the third party insurance, we saw uh, the different coverages. So what all things, under what all things these third party insurance gets covered. So mainly three coverages are there. First one is death or bodily injury, and the second one is damage to property of a third party, and the third one is legal costs incurred in defending claims. So these are the three coverages that the third party insurance mainly dealt with. Okay. Now, after that, we saw Motor Accidents Claims Tribunal. So, Motor Accidents Claims Tribunal, we know that Motor Accidents Claims Tribunal, it is actually a special court that is established under Motor Vehicles Act 1988 to provide speedy and effective justice to victims of motor vehicle accidents or their legal heirs. So, Motor Vehicles MACT, Motor Accident Claims Tribunal, it is actually a special court that mainly deals with the road accidents, and it is mainly established under Motor Vehicles Act 1988 to provide speedy and effective justice to the victims of motor vehicle accidents or their legal heirs. So this is the main concept of Motor Accidents Claims Tribunal. Mainly, this Motor Accidents Claims Tribunal deals with exclusively claims for compensation. It gives compensation which is arising from death, bodily injury or property damage. Death, bodily injury or property damage caused by road accidents. Okay. Then section 165 to 176 of the Motor Vehicles Act 1988 deals with MACT. Section 16. Remember, motor, that is Motor Vehicles Act 1988. So in this act, particularly section 165 to 176, always remember this section. Sometimes the questions can be asked under which section of the MV Act 1988 the tribunal is dealing with. So the questions can be asked. So always remember this section 165 to section 176 of the MV Act. It deals with Motor Accidents Claims Tribunal, and it is mainly established to replace the civil court in handling motor accident cases, and also to provide the remedy faster and also in simpler way. After that, we saw the compensation. So compensation is mainly going like this, that is the state government established a tribunal. By who established Motor Accidents Claims Tribunal? The state government. Through notification, it has established Motor Accidents Claims Tribunal, and the composition goes like this. It consists of one or more members. One or more members are there. It can be one. It can be more than one, two also. And the presiding officer is mainly usually a district judge. Okay, remember, presiding officer is usually the district judge or additional district judge. Okay, district judge or additional district judge. And after the composition, we saw the appeal. And if any of the award, if the award is actually, if the party is aggrieved by the award, mainly the claimant, mainly the petitioner is aggrieved by the award that was passed by the Motor Accident Claims Tribunal, then he or his legal heirs can file an appeal where to High Court, within 90 days. So this is the main concept of Motor Accident Claims Tribunal. Okay. Now we can say so once again we can discuss the MACT completely. That is, yesterday also we have discussed no fault liability, then right. Today, once again, we can discuss this MV Act. So, MV Act, when we discussed this topic yesterday, we saw that Motor Vehicles Act 1988 regulates all aspects of road transport vehicles in India, and for it replaced Motor Vehicles Act 1938. So always remember this section to actually replace Motor Vehicles Act 1939, and after this particular act, this Motor Vehicles Act 1988 has been established. So its main objective is what we yesterday saw, to ensure road safety, control traffic, and protect the rights of road users. So this is the main objective of the MV Act. And after that, we saw some of the important definitions that are mainly dealing with this act. First one is motor vehicle. Motor vehicle, we know, any mechanically propelled vehicle adapted for use on roads. Any vehicle that can use on roads, that is mainly meant by motor vehicle. And section 2 clause 28 of the MV Act mainly deals with motor vehicle. And after this particular definition, we have seen the definition of driver. Driver is mainly discussed in section 2 clause 9 of the MV Act. Driver means who, a person in control of the vehicle. A person who controls the vehicle is the driver. Then after the driver, we see owner. The term owner is mainly discussed in section 2 clause 30 of the MV Act. Owner means whom, the person in whose name the vehicle is registered. Okay, the person in whose name the vehicle is registered is mainly termed as owner. Then after the owner, we have seen another one definition, that is public place. Public place is mainly defined in section 2 clause 34. Remember this section. Okay, so section 2 clause 34 of the MV Act 1988 mainly deals with the term public place. Well, public place means any place where the public has access. Then another one important topic that we have discussed yesterday is no fault liability. So before the no fault liability, I also have to remind you some another liability that we have discussed. In tort, we saw absolute liability, and what we have seen absolute strict liability, and no fault liability. So never get confused about these three liabilities. Okay, so when we discussed in tort, we have seen that a strict liability is mainly deals with the case Ryan versus Fletcher. And after that, we saw absolute liability. Absolute liability is mainly discussed with the case where MC Mehta versus Union of India. And after that, we have seen no fault liability. No fault liability is mainly discussing in with respect to uh, this this accident, road accident cases. This particular term is mainly discussed. So here, no-fault liability, actually, when we saw yesterday, we have seen that the concept of law, no-fault liability, actually it was introduced to provide quick compensation to road accident victims. So here, the road accident victims, they never have to prove the negligence of the driver, or here they do not have to prove, even if they have not proven uh, what it is the owner or the insurer of a motor vehicle is liable to pay compensation. So here what happens? So no for liability. Always remember this term. No in no for liability here the victims, they do not have to prove the negligence of the driver. The insurer or the owner of the motor vehicle is liable to pay compensation regardless of who was at fault. Okay, so this is the concept of no fault liability. Then after that we have seen the MV Act deals with no fault liability, that is mainly discussed in section 140 of the MV Act. That is, section 140 says the liability to pay compensation in certain cases on the principle of no fault. So we saw this particular section yesterday. And after that, we seen where mainly this no fault liability applies, mainly in which all cases is low. This no fault liability applies applicable in the cases of death or permanent disablement due to a motor accident. So it is mainly happens in the case of a death. It is mainly applied in the case of a death or permanent disabled, and the compensation, the minimum compensation rupees 50,000 in the case of a death and rupees 25,000 in the case of permanent disablement. We saw yesterday. And after that, we hear one thing in particular I have to stress on. One thing is this no for liability statutory and absolute. Okay, it is statutory and absolute. And so this is the concept that we have discussed yesterday. Then we saw today's third party insurance. We discussed this thing. Then role of third party insurance in MACT. Then after that we saw coverages that deals with third party insurance, mainly three. Always remember these three coverages, that is death or bodily injury, damage to property. Mainly these are the three coverages: death or bodily injury, damages to property, and another thing is legal costs incurred in defending claims. Okay, then come after all this third party insurance, and at last we see so Motor Accident Claims Tribunal for adjudicating the matters that mainly connects with road accidents. Remember, we all know that. And we saw mainly the compensation is given for death, bodily injury, or property damage. Okay, then we have seen the sections, section 165 to 176 of the, remember, Motor Accident Claims Tribunal. So this particular tribunal under this act, section 165 to 176 of this act mainly deals with Motor Accidents Claims Tribunal. Then after the section we saw the compensation, who establishes the the Motor Accidents Claims Tribunal, state government by notification, and it consists of one or more members. Who is the presiding officer? The presiding officer is a district judge or additional district judge. We have seen this. Then after that we saw if the claimant or if the petitioner is aggrieved with the order of the Motor Accidents Claims Tribunal, he can actually go for appeal, where in High Court within 90 days. Remember this term, within 90 days. So these are the topic we discussed today. Now we can see one of the uh, one of the most interesting legal field, which is IPR. So intellectual property rights. Okay, when we say about intellectual property rights, we know that. So we have studied in our LLB, and the the people who have pursued I know here LLM graduates are there. So mainly you all know that the concept of intellectual property, and when we say about intellectual property law, this intellectual property right is entirely different from our usual law, right? We know the criminal law, civil law. So this particular law is actually entirely different from such areas. So we can see the definition of intellectual property rights. So IPR, intellectual property right, refers to the legal right given to creators or inventors to protect their creations, inventions, or work from unauthorized use by others. These rights allow the creator to control how their intellectual creations are used and to earn recognition or financial benefits from them. So this is one of the longest definition. In simple terms, what is meant by intellectual property rights? So it is a right which is given to the inventors or which is given to the creators to protect their invention or creators. It is a right which is mainly given to the inventors or which is mainly to the creators to protect their legal right, to protect their work from unauthorized use by others. Okay, from unauthorized use by others to protect their to protect their work or their invention. Mainly, this right has been granted, and these right allow the creator to control how their intellectual creations are used and to earn recognition or financial benefits from them. So these are the simple definition of intellectual property rights. So I hope you got the definition. Now we can see the different types of intellectual property rights. Okay. So here I have given only some definition. The detailed explanation is maybe we can discuss in the next class. Okay. Here types of intellectual property rights. First one is patent. Patent means what? Patent is actually the patent right is mainly granted to the invention. It can be the product for patent, and also this particular right, that is patent right, is mainly given to invention, new products or process. So patent is given to product and also to process. So remember this term. Patent right is mainly given to new products or the process. And the duration of the patent right is 20 years from the filing date. So duration is, so we have Patent Act, right? We have Patent Act, and as according to this Patent Act, mainly the patent right has been granted. So this patent is actually protect the invention. Mainly the patent is given to product and also to process. The duration is 20 years from the filing date. So for example, a new type of mobile battery or drug formula. So this type, for its process or for the product, we have the patent has been granted. So we saw patent. First intellectual property right is patent. Patent is mainly given to invention, and the duration is 20 years from the filing date, and we have seen an example also. Next is copyright. So what is meant by copyright? Copywriters protects literary, musical, artistic work, films, software, etc. So, copyright is a right which has been mainly granted to the authors, which has been authors or this which has been granted to authors or the creators for literary, musical, artistic work, film, software, etc. For these things, the copyright has been granted. So its duration is lifetime of the author plus 60 years. Okay, lifetime of the author plus 60 years is its duration. So here also the example is given: books, movies, songs, or computer programs. So this is the concept of copyright. Now we can say trademark. Trademark protects brand names, logos, slogans, and symbols that distinguish goods and services. So trademark. So now, for example, if we say Bata, we know its symbol Bata. Then Nike, we know the tick mark of Nike. So from that mark itself, we can identify. So this product is actually the Nike's product. We know it. So trademark actually protects the brand names, logos, slogans, and symbols that distinguish goods or services. And this duration is uh, 10 years, and it can renewable indefinitely. An example, Nike's tick logo or Coca-Cola's name. Okay, so this is the concept of trademark. And after that, we can see another intellectual property right, which is geographical indication. Okay, geographical indication. Geographical indication protects products originating from specific region with unique qualities or reputation. So this actually So this geographical indication or GI tag, actually GI tag is mainly given to the to any of the things, to any of the products that is merely originating in a specific region with the what, with unique qualities of reputation. So for that products, for such type of products, mainly GI tag has been given. Duration is 10 years. It is also renewable. And here an example is given: Darjeeling tea, Kanchipuram silk, Alapi coil. So these are the example of geographical indication. Okay. So after that, we saw trade secret. Trade secret, trade secret is what? Trade secret protects confidential business information that gives a competitive edge. So if we say about trade secret, for example, if we say KFC's recipe, it is actually a unique one, right? So if so for such secret, such uh, such uniqueness is actually protected by trade secret. Duration protects confidential business information that gives a business edge. So this when I now I so now I told one example that KFC's that trade secret, it is, so it helps them to, so this, because of their trade secret, they actually flourish in the market, we know it. So this particular right actually protects, that means a trade secret actually protects confidential information that gives a competitive edge. Duration, as long as the secret is maintained. Example, Coca-Cola formula or Google search algorithm, and another thing is KFC secret. Next intellectual property right is plant variety protection. Protects new varieties of plants developed by breeders. Duration 15 to 20 years depending on the species. New varieties of plant developed by breeders. So this plant variety protection is another type of intellectual property right. This actually, this we all know high yield variety of HIV seeds, high yield variety of seeds. So such seeds or such type of seeds all are protected by this type of right, this, that is plant variety protection, and this duration is 15 to 20 years depending on the species. So these are the rights mainly IPR is discussing. Okay, once again we can see, we saw the definition of intellectual property right, and we have seen that intellectual property right is a right that has been granted to the creators or inventors for protecting their invention or protecting their creations from unauthorized users. So this is the concept of intellectual property right. And after that, we saw that types of intellectual property right. We saw patent. Patent is what? Patent is mainly granted to inventions. Mainly patent is given to product for in two cases, that is product patent and process patent. Duration is 20 years, and we saw one example, that is a new type of, that is for your understanding, I have mentioned the example, that is a new type of mobile battery or drug formula. So this is the concept of patent. After that, we saw copyright. Copyright actually protect literary, dramatical, musical, films, software, etc. And the copyright protection is mainly given, the duration is lifetime of the author plus 60 years. Okay, so remember, duration is lifetime of the author plus 60 years, and the examples are book, movie, songs, or computer program. So this is the concept of copyright. After that, after the copyright, we saw another type of intellectual property, trademark. Trademark actually protect brand names, logos, slogans, and intellectual property that distinguishes goods or services. And its duration is 10 years, and it can be renewable indefinitely. Example, Nike's tick logo, or Coca-Cola's name. So this is trademark. After trademark, we have seen geographical indications. Geographical indications mainly protects. Geographical indications protects products originating from a specific region with unique qualities of reputation. Duration is 10 years, which is renewable. Example, Darjeeling tea, Kanchipuram silk, Alleppey coil. So these are the example of geographical indication. So after geographical indication, we have seen trade secret, and always remember when we say about trade secret, remember the example that I have said, KFC's that recipe secret. Okay, so this particular trade secret protects confidential business information that gives a competitive edge, duration, as long as the secret is maintained. And the example also we have seen Coca-Cola formula or Google search algorithm or the KFC's recipe. Another one intellectual property right we saw is plant variety protection. Okay, plant variety protection, and this protects new varieties of plants developed by breeders. Duration is 15 to 20 years depending on the species. So these are the rights that we have seen in intellectual property law. Then coming on to next, we can see the important conventions that are deals with IPR. Okay, the important convention that mainly deals with IPR. First one is Paris Convention that was happened in 1883. Okay, first one is Paris Convention. That convention's full name is Paris Convention for the protection of industrial property. So another thing that we have to discuss is before the term intellectual property, the term was industrial property. Okay, before the term intellectual property, that mm, the term that has been discussed is industrial property, and this particular convention covers patent, trademark, industrial designs. Patent, trademark, industrial designs. Okay, now this convention provides national treatment, same protection as nationals of that country. Here it says that it actually gives national treatment to these rights. That is, to patent, trademark, industrial designs, it provides national treatment. Introduces the right of priority. Once an application is filed in one member country, the applicant can claim priority in other countries within 12 months for patent, 6 months for trademark. Right of priority here means what? If once an application it is filed in one member country, the applicant can claim priority to that application in other countries. Okay, this means that once an application is filed in one member country, that means the members of the Paris Convention. So here, once an application is filed in one member country, then what happened? The applicant, he can claim priority in other country within 12 months for patent, within 12 months for patent, and 6 months for trademark. And this particular convention, copyright work, book, music, films, art, etc. Berne Convention actually covers uh, copyright, that is, but it is mainly established for the protection of literary and artistic works, and it covers copyright works, book, music, films, art, etc. So these are the area where Berne Convention covers. So here protect works automatically, no need for registration. So after 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 creating the work, that means any book, music, films, etc. Here no needs for registration. Automatically the protection has been granted. Duration is life of the author plus 50 years. Okay, life of the author plus 50 years is the duration. Many countries, including India, extend it to 60 years. Firstly, life of the author plus 50 years, and now we know that in India as well as many countries, life of the author plus 60 years is the duration, and it is administered by WIPO, World Intellectual Property. It is also administered by WIPO. So Paris Convention also administered by WIPO, and Berne Convention also administered by WIPO. Always remember, Paris Convention covers patent, trademark, and industrial designs. Berne Convention covers mainly copyright works and it is mainly established in 1886, and this particular convention is administered by WIPO. Okay, another one is Madrid Agreement and Madrid Protocol. Madrid Agreement happens in 1891 and Madrid Protocol happens in 1989. And this particular agreement covers trademark, allow international registration of trademark through one single application filed at WIPO. Simplifies protection of a trademark in multiple countries. So here according to Madrid Agreement and Madrid Protocol, what happens, it actually allows international registration of trademark through one single application. So international registration of trademark through one single application, we can register the trademark through by international level. Okay, and it is mainly filed at World Intellectual Property Organization, and it simplifies protection of a trademark in multiple countries. Okay, this particular agreement is also administered by WIPO. So always remember, so when the questions can be asked, Madrid Agreement and Madrid Protocol covers which aspect of intellectual property right? Trademark. Remember that type, trademark. Okay, so Madrid Agreement, it was established in 1891 and Madrid Protocol, it was established in 1989. Okay, so TRIPS agreement. TRIPS agreement is one of the major important agreement that mainly deals with intellectual property right. So its name is Agreement on Trade Related Aspects of Intellectual Property Right. Okay, TRIPS, Agreement on Trade Related Aspects of Intellectual Property Right, covers all types of IPR. It covers, it is not covering the particular right, but it covers all type of IPR, that is patent, copyright, trademark, geographical indication, designs, etc. It covers all type of IPR. So it also sets minimum standard of IPR protection for all WTO member countries. So World Trade Organization member countries, and for all WTO's member countries, it actually sets minimum standard of IPR protection. It actually links IP protection with international trade. So the connection between intellectual property protection and international trade mainly established through TRIPS agreement. Okay, TRIPS agreement, and here always remember TRIPS, it is administered by World Trade Organization, not WIPO. Other all agreements mainly administered by WIPO, but TRIPS agreement is administered by World Trade Organization. So TRIPS agreement, it is established in 1994, and the full name or the definition of TRIPS agreement is, the expansion of TRIPS agreement is trade related aspects of intellectual property right, and this particular agreement covers all types of IPR, that is patent, copyright, trademark, geographical indications, design, etc. And it sets minimum standards of IPR protection for all WTO member countries. And another one important point is what this TRIPS agreement actually provides. It actually links IP protection with international trade. Okay, and TRIPS agreement is administered by World Trade Organization, not WIPO. So this is all about TRIPS agreement. Next is Lisbon Agreement. Lisbon Agreement is happens in 1958, and it covers appellations of origin, geographical indication. Lisbon Agreements actually covers geographical indications. So it according to this agreement, it protects products that originate from specific geographical areas like Champagne, Darjeeling tea, etc. So Lisbon Agreement, it mainly established in 1958. It covers appellations of origin or geographical indications, and it protects products that originate from specific geographical areas like Champagne, Darjeeling tea. So these are the things that we discussed in intellectual property rights. So once again we can see the convention that deals with the intellectual property rights. So we saw Paris Convention. Paris Convention is mainly established in 1883, and it covers Paris Convention for the protection. The full name is Paris Convention for the Protection of Industrial Property. So never get confused about intellectual property and industrial property. So before the term intellectual property, the term was industrial property. So full name is Paris Convention for the Protection of Industrial Property, and it covers patents, trademark, industrial design. So these three areas which where the Paris Convention has been covered, and it states that it provides national treatment, that is same protection as nationals of that country, and it introduces right to priority. So once an application is filed in one member country, the applicant can claim priority in other countries within 12 months in the case of patents and 6 months in the case of trademark. So Paris Convention has been, in the case of Paris Convention has been given more preference to patents, trademark, and industrial designs. Okay, and this particular convention is administered by WIPO. And after that, we have seen Berne Convention. Berne Convention has been established in 1886, and the full name of Berne Convention is Berne Convention for the Protection of Literary and Artistic Works. So from that name itself, it has been given preference to copyright. It covers copyright works, books, music, film, artistic, literary, all these things, etc. Key points: it protects work automatically, no needs of registration. How the duration goes here: life of author plus 50 years. So this is the duration that has been given by Berne Convention. But in the case of India and in the case of many other countries, it has been extended to 60 years, and this particular section is also administered by WIPO. Then after that, we saw Madrid Agreement that happens in 1891, and Madrid Protocol that happens in 1981, and Madrid Agreement and Madrid Protocol that covers the area of trademark. So here it allows international registration of trademark through one single application filed at WIPO, and it actually simplifies protection of a trademark in multiple countries. So this is the concept of Madrid Agreement and Madrid Protocol, and Madrid Agreement is also administered by WIPO. Then after that, we have seen TRIPS Agreement. This TRIPS Agreement has been established in the year 1994, and the expansion of TRIPS agreement is trade related aspects of intellectual property. So this is the expansion, and it covers all the types of IPR, which includes patent, copyright, trademark, trade secret, GIs, etc. And it actually sets minimum standard of IPR protection for all the World Trade Organization member countries. So the members of the World Trade Organization, and they have set minimum standards for all the types of intellectual property rights, and this TRIPS agreement is mainly administered by World Trade Organization. Remember, World Trade Organization, not WIPO. And after that, we have seen Lisbon Agreement. Lisbon Agreement has been established in the year 1958, and it covers the appellations, the geographical indications, appellation of origin, and the example also we have seen protects products that originate from specific geographical areas like Champagne, Darjeeling tea, etc. So today we have discussed MB Act, and we saw third party insurance, Motor Accident Claims Tribunal. After that, we saw intellectual property right. When we say about intellectual property right, we have seen its definition, different types of intellectual property right, that is patent, copyright, trademark, geographic indication, trade secret, plan variety protection. So after discussing all the types of intellectual property right, and we have discussed its duration also: patent for the protection of invention, patent has been given to product as well as the process, and the duration is 20 years. Copyright is mainly granted to literary, artistic, dramatic. For all these things, the copyright protection has been granted, and the duration is lifetime of the author plus 60 years. So this is the duration. And after that, we have seen trademark. Trademark is protection of brand names, logos, slogans, symbols that distinguish goods or services from one another. So So its duration is 10 years and it is renewable indefinitely. Then after the trademark, we have seen geographical indications. Geographical indications mainly, this protection is mainly granted to the products that is originating from a specific region with the unique qualities or reputation. So for such products, the GI tag has been granted and the duration is 10 years. The example is Darjeeling tea, Kanchipuram silk, all are its example. Then after that, we have seen trade secret. Trade secret actually protects the confidential business information. Okay, and the example also we saw the Coca-Cola's formula, KFC's trade recipe, KFC's recipe. All these are the examples of trade secret. And after the trade secret, we have seen another one type of intellectual property, that is plant variety protection. Plant variety protection is protects new varieties of plants that is developed by breeders, and its duration is 15 to 20 years depending on the species. After that, we saw the important convention, Paris Convention, Bern Convention, Madrid Protocol and Agreement, then TRIPS. Remember, TRIPS is the important thing. After that, we have seen Lisbon, Lisbon Agreement. Yes. So these are the things that we discussed today. I hope you all understood about the topic, and I'm winding up for now. Thank you.